Hello, everybody, and welcome to History / Law Bite number 310, dated September 25th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in. This History / Law Bite is entitled Jacobson versus Massachusetts, 197 U.S. 11, 1905. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Warresley Shelton, M.A., and in addition to that, please also hit that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much for tuning in, and thank you so much in advance for your subscription. So again, this video is entitled Jacobson versus Massachusetts, 1905. This was a landmark U.S. Supreme Court decision in the very early 20th century that dealt with the constitutionality of mandatory vaccination laws. That, of course, is definitely a relevant thing in today's time with the COVID-19 pandemic and various entities making COVID-19 vaccinations mandatory. All right? So, as the old saying goes, those who fail to learn their history are doomed to repeat it. And, as directly from Holy Scripture, everything happens in cycles. There's nothing new under the sun. Ecclesiastes 1:9, by the way. Everything that has happened will happen again. Okay? So, as mandatory vaccination regulations are controversial today, they were no less controversial when they were enacted more than a century ago. All right? So let's get into Jacobson versus Massachusetts, beginning the same way the U.S. Supreme Court does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So, Jacobson versus Massachusetts, all right? Mr. Chief Justice, and may it please the court. So, in the early part of the 20th century, Massachusetts was one of several states, 11 to be specific, which had laws on the books that required mandatory vaccinations, okay? So in the Commonwealth, the state had delegated the power to local boards of health in the state's municipalities to enforce mandatory vaccinations, which of course were free of charge for all individuals age 21 and over, if they determined that it was necessary for the health and safety of the community in question. All right. With it, a $5 fine was attached for those who refused to receive a mandated vaccination as required. All right. Now, that might not sound like a whole heck of a lot, but keep in mind, this is the year 1902. All right. And that was roughly $150 in today's money. Big difference, isn't it? So, the municipality of Cambridge, Massachusetts, adopted such a vaccination rule in 1902, like I said, when it was faced with an outbreak of smallpox virus. Okay, and the law that was enacted by Cambridge required all residents to either be vaccinated or revaccinated against the virus. In this case, our petitioner, the Reverend Henning Jacobson, who was a local pastor and a Swedish immigrant, elected not to be vaccinated. His significant opposition stemmed from previously being vaccinated while he was in Sweden against smallpox, and the adverse reaction that followed that affected both him and his son. As such, Reverend Jacobson was prosecuted and fined $5. Okay, again, that was roughly $150 in today's money. All right. So in challenging the law through the Massachusetts courts, all the way to the Supreme Court of the United States. Jacobson argued that the mandatory vaccination law was arbitrary, oppressive, and unreasonable. Okay, he contended that no one should be forced to be vaccinated against their will, and a state law requiring this violated his liberty, guaranteed by the 14th Amendment to the United States Constitution. Needless to say, the Massachusetts courts ruled against Jacobson's claims from the trial level all the way to the Supreme Judicial Court, which is the state Supreme Court, by the way. So the question presented to the Supreme Court of the United States was as follows. Did the Massachusetts law requiring mandatory vaccinations violate the 14th Amendment's due process clause right to liberty? And the answer was no. In a 7-2 decision by Associate Justice John Marshall Harlan, the court affirmed the constitutionality of the Massachusetts law, and the judgment of the Supreme Judicial Court of Massachusetts, was affirmed accordingly. The Supreme Court of the United States reasoned that states had the legitimate police power to enact reasonable regulations to protect the public health and safety. Ladies and gentlemen, mandatory vaccinations were certainly a product of such reasonable regulations. Harlan's opinion held as follows. The police power of a state embraces such reasonable regulations relating to matters completely within its territory and not affecting the people of other states, established directly by legislative enactment, as will protect the public health and safety. While a local regulation, even if based on acknowledged power, police power of a state must always yield in case of conflict with the exercise by the general government of any power it possesses under the Constitution, the mode or manner of exercising its police power is wholly within the discretion of the state, so long as the Constitution of the United States is not contravened, or any right guaranteed or secured thereby is not infringed, or not exercised in such an arbitrary and oppressive manner as to justify the interference of the courts to prevent wrong and oppression. The liberty secured by the Constitution of the United States does not import an absolute right in each person to be at all times and in all circumstances wholly freed from restraint, nor is it an element in such liberty that one person or a minority of persons residing in any community and enjoying the benefits of its local government should have power to dominate the majority when supported in their action by the authority of the state. Okay? It is within the police power of a state to enact a compulsory vaccination law, and it is for the legislature and not for the courts to determine in the first instance whether vaccination is or is not the best mode for the prevention of smallpox and the protection of the public health. Additionally, Harlan's opinion stated that there is, of course, a sphere within which the individual may assert the supremacy of his own will and rightfully dispute the authority of any human government, especially of any free government existing under a written constitution, to interfere with the exercise of that will. But it is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint, to be enforced by reasonable regulations as the safety of the general public may demand. Lastly, Harlan conceded that before closing this opinion, we deem it appropriate in order to prevent misapprehension as to our views, to observe, perhaps to repeat, a thought already sufficiently expressed, namely that the police power of a state, whether exercised by the legislature or by a local body acting under its authority, may be exerted in such circumstances or by regulations so arbitrary and oppressive in particular cases as to justify the interference of the courts to prevent wrong and oppression. Extreme cases can be readily suggested. Ordinarily, such cases are not safe guides in the administration of the law. It is easy, for instance, to suppose the case of an adult who was embraced by the mere words of the act, but yet to subject whom to vaccination in a particular condition of his health or body would be cruel and inhumane in the last degree. We are not to be understood as holding that the statute was intended to be applied to such a case, or if it as so intended that the judiciary would not be competent to interfere and protect the health and life of the individual concerned. All right? All laws, this court has said, should receive a sensible construction. General terms should be so limited in their application as not to lead to injustice, oppression, or absurd consequence. It will always, therefore, be presumed that the legislature intended exceptions to its language, which would avoid results of that character. The reason of the law in such cases should prevail over its letter. So the judgment of the court here affirmed the Supreme Judicial Court of Massachusetts. All right? So Harlan's opinion is pretty direct and clear that the state most assuredly had the power to enact mandatory vaccination laws to protect the public health and safety. All right? One's liberty as an individual is not so grand and not so sacred and important that it overrides in all circumstances the needs of the community at hand. All right? You are not that special. All right? That your personal liberty outweighs the general needs and the health and safety of the community. This is essentially what Harlan's opinion is saying. But he concedes at the end that there are indeed certain instances where an individual's liberty may be defended through the courts against arbitrary and oppressive actions by government. All right? But this was not the circumstance in which that would apply. All right? So he makes a very clear distinction that the state has this power. All right? And it is to write the law itself, okay, in a sensible manner, and to generally provide exceptions to said rule when necessary. All right. Obviously, thus not being applicable to everybody in all circumstances. And I'm quite sure the Massachusetts statute certainly had such exceptions. All right. But in any case, whatever they were, Reverend Jacobson was not subject to those exceptions. All right. And therefore, the constitutionality of Massachusetts vaccination law was affirmed in its form and in its application by the Supreme Court of the United States. All right. Justices Brewer and Peckham dissented, respectively, from the court's decision. So this case, obviously, certainly from 1905 to present, that is 116 years as of the time of this recording. All right, this case has a lot of relevance and has been referenced, okay, on more than one occasion with respect to entities such as colleges, universities, and other institutions that have required mandatory COVID-19 vaccinations, you know, for their student body, for their employees and other things. And this precedent affirms the constitutionality of such vaccination requirements by entities, all right? Because these entities are taking necessary steps to protect the public health and safety, all right? Individual liberty, ladies and gentlemen, while it is definitely important, and no one would suggest that it's not, but individual liberty in general circumstances to protect the public health and safety, that liberty does not override the greater good to protect the public health, all right? It's not all about you, all right? That's what the court is essentially saying, all right? The public health, the state's power here, definitely includes the ability to protect the public health and safety. And that, of course, certainly extends to other institutions that are attempting to protect the public health, all right, whether it be a state institution and, of course, whether it be private entities that want to ensure the safety of their employees as well as the public, all right? So this decision is definitely a very powerful and very relevant precedent, all right, arguably just as much now as it was when it was handed down in 1905. All right. So once again, this case is Jacobson versus Massachusetts, properly referenced as 197 U.S. 11, 1905. If you have any questions or controversies, you can leave them down below. I'll be happy to answer them. All right. If you learned something from this video, enjoyed it, gained some insight, drop me a like. Just hit that like button. You know, it would be appreciated more than you'll ever know. And if you've not yet subscribed to my YouTube channel, Warresley Shelton MA, please do so now. All subscriptions and all likes matter. All right. So thank you so much for listening to this video. Hope you learned a little bit from it. You know, that's my whole purpose in life, to educate you all. All right. And actually make you enjoy the education as well. Take care. Stay safe out there. And I will talk to you at the next video. Peace.